和大家就这个各类热门的话题进行华尔街论坛的大讨论。那么我们明天再见。
大家好，欢迎来到我们的六度探索节目。今天我们将探讨中国即将举行的第3次全会，这次会议对于恢复市场信心至关重要。新加坡国立大学东亚研究所所长 Alfred Shipke 强调，中国需要提供清晰的方向和锚点，并且进行市场机制和结构性改革。他指出，中国尽管面临诸多挑战，仍然对外开放，并呼吁加强财产权和地方政府财务的稳定性。此外，他还提到中国需要在需求侧进行结构性改革，并强调了产业政策在电动车 EV 领域的成功。Shipke 认为，中国有潜力继续以相对高速增长，但这必须是可持续的，并且需要新的技术和市场机制来提升生产率。请大家继续收看详细内容。欢迎收看六度解析，我是主持人。今天我们要深入探讨一篇来自南华早报的重要文章，标题是学者第3次全会需提供明确方向和锚定点，推进改革。文章由 Frank Tang 撰写，发表于2024年7月5日。文章探讨了中国即将召开的第3次全会及其对经济改革和市场信心的重要性。文章首先引用了新加坡国立大学东亚研究所主任 Alfred Shipke 的观点。他强调，第3次全会需通过提供明确方向和锚定点来恢复市场信心，同时还需要市场机制和结构性改革。Shipke 在接受南华早报采访时指出，文件应解决一些关键问题，比如加强创业产权和稳固地方政府财政状况。此外，全会还需向全球传递中国仍然开放的信号，尽管面临各种挑战。北京方面确认，新的中央委员会将于7月15日召开为期4天的第3次全会，旨在制定中国长期增长路径，包括未来10年的经济和科技发展目标，以及到2035年的一系列中期目标。Shipke 从2013年起担任国际货币基金组织 IMF 驻华高级代表，期间推动了 IMF 关于中国结构性改革的建议，而不是简单的债务累积。他指出，现在的政策制定者面临的挑战比2013年更多，但中国拥有庞大的国内市场和新兴产业，可以填补房地产行业的空白。Shipke 强调，家庭、企业和地方政府都在寻找明确方向和锚定点，这将有助于提升信心，尤其是在消费疲软的情况下。数据显示，中国中等收入人口约为4亿，但许多家庭在紧缩开支和增加预防性储蓄。2023年，中国家庭银行存款增长了 16.67 万亿元人民币，2024年前5个月增长了 7.13 万亿元。尽管面临诸多挑战， Shipke 指出中国在电动汽车 EV 领域的成功使用工业政策，并建议可能向西方进行技术转让。他认为，虽然工业政策不总是成功，但中国在 EV 领域的早期投资和资源投放获得了成功，这在一定程度上改变了历史上技术转移通常来自西方的格局。在国内方面， Shipke 认为北京需要进行必要的结构性改革，重点应放在需求侧的提升，而不是供给侧的改进。他警告称，政府目标之间可能存在冲突，例如 5% 的年度 GDP 增长目标与 3% 的财政赤字占 GDP 比例目标之间的冲突。尽管中国政府在政策协调方面有所改进，但仍需谨慎处理这些目标之间的平衡。Shipke 还提到，每当经济放缓时，中国人民银行总是面临提供支持的压力，因此财政政策需要扮演更积极的角色。尽管中国迄今为止抵制了大规模刺激，但仍有不断放松的呼声。央行计划在二级市场购买国债，许多人将其解读为量化宽松的迹象，尽管北京多次否认。Shipke 总结道，中国有潜力继续以相对高的速度增长，但必须是可持续的，越来越依赖于生产率驱动。生产率可以来自新技术、新商业投资，以及允许企业失败的市场机制。他警告，目前仍有资源错配的风险。接下来，我们将从多个角度深入探讨这篇文章涉及的背景、内容和观点。首先，从历史角度来看，第3次全会在中国政治和经济改革史上具有特殊意义。 1978年的第三次全会开启了中国的改革开放，2013年的第三次全会提出了市场在资源配置中发挥决定性作用的改革方向。本次全会同样承载着重大历史使命，需要在全球经济不确定性增加和国内经济增长放缓的背景下，为中国未来10年的发展制定清晰路线。其次，从经济学角度分析 ，Shipkey 所提到的明确方向和锚定点其实反映了市场主体对于政策确定性的需求。在经济学中，政策不确定性往往会导致企业和家庭的投资和消费决策推迟，从而影响经济增长。通过提供清晰的改革方向和政策信号，政府可以降低不确定性，提升市场信心。从政策角度来看，Shipkey 提到的需求侧改革和财政政策的积极作用，显然与当前中国经济的现实需求相契合。过去几年，中国更多依赖供给侧改革，如减税降费和结构调整，但需求侧的刺激相对较少。在经济增速放缓、消费疲软的情况下，需求侧改革，特别是通过财政政策刺激消费和投资，显得尤为重要。从国际角度来看，Shipkey 所提到的技术转让和国际合作也值得关注。随着中国科技实力的提升，特别是在电动汽车等新兴产业的崛起，中国有机会在全球技术格局中扮演更主动的角色。这既是中国科技进步的体现，也为全球技术交流和合作提供了新的契机。最后，从社会角度来看，中等收入群体的消费行为和储蓄倾向反映了经济结构性问题和社会风险偏好的变化。如何通过政策手段激发消费潜力，增强社会信心，也是未来政策制定者需要重点考虑的问题。总结而言，第三次全会将承载中国未来10年发展的重任，通过提供明确方向和锚定点，进行必要的结构性改革，积极发挥财政政策的作用，中国有望在全球经济舞台上继续保持竞争力。而如何平衡多个政策目标，推动可持续增长，则需要政策制定者的智慧和远见。感谢收看今天的6度解析，我们下期再见。谢谢大家收看6度探索，这是一个由科学家、经济学家、媒体人、工程技术人员合作建立的新型媒体，网友与6度 AI 参与合作完成各种内容，这些内容不能作为任何决策或法律的意见。这是一个新型的试验性媒体方式，我们希望得到大家的支持，修正错误。网友可以参与讨论，也可以向万能的6博士提出你能想出的任何问题。6度世界网址是6do World， 请介绍给你的亲朋好友。
想成为全球沟通达人吗？6do 人工智能语音克隆技术帮你实现梦想。在这个新时代，语言障碍已成过去。我们隆重推出6do人工智能语音克隆系统，这项由欧美亚顶尖专家研发的突破性技术，让你可以克隆自己的声音，并将文字转换成145种语言和方言，提升你的个人和职业生活。想象一下，你可以在日本参加商务会议，在巴西上课，或与意大利的朋友畅聊，而这一切都用你自己的声音、他们的语言进行。操作简单，只需点击几下，无需复杂的科技知识，就能享受无缝衔接的体验，让世界向你敞开。从商务到教育，从媒体到娱乐，应用场景无处不在。企业可以更好地与全球客户建立联系。教育机构可以提供多语言学习，媒体可以创作更丰富的内容，触达更广泛的受众。今天就来体验这项革命性技术吧。访问：迈向你的声音无国界的未来。
So Florida Statute Section 287138, otherwise known by the bill upon which it's based, SB 264, was passed in the state of Florida legislature in 2023. The stated rationale of the law is to stop Chinese Communist Party influence in the state of Florida. Governor Ron DeSantis, in the run-up to the presidential election in May of 2023, stated Florida is taking action to stand against the United States' greatest geopolitical threat, the Chinese Communist Party, end quote. The law does this in a kind of curious way by preventing Chinese nationals and Chinese entities from owning property in the state of Florida. So to get a bit more granular, SB 264 is quite expansive in what it tries to do. It prohibits contracting with entities of foreign countries of concern, prohibits foreign principals from purchasing agricultural land and any other real estate in the state of Florida, and requires foreign principals that own such land to register with specified departments, and imposes various penalties for failure to meet the foregoing requirements. So even more specifically, it creates an unusual two-tier system. The first tier is in regards to foreign principals from foreign countries of concern. So that's not just China, but also Russia, Iran, North Korea, Cuba, Venezuela, Syria. It prohibits foreign principals from property ownership within 10 miles of any military installation in the state. The second tier is specific to China. Section 692.204 includes, quote, any person who is domiciled in the PRC, end quote, is subject to the law. So it's much broader in scope as regards to this category. So it's not just those within 10 miles of a military installation, but those transactions that are prohibited are effectively for any acquisition within the state of Florida. So Chinese nationals cannot directly or indirectly own, have a controlling interest in, or acquire by purchase, grant, devise, or descent any interest except a de minimis indirect interest in real property in the state. So again, it's a statewide ban. There's one small exception as regards to a non-tourist visa or an asylee. So they can own property within 5 miles of the military installation. Furthermore, within this two-tier structure, for the first tier, the penalties are less severe. So if somebody violates the law, they receive penalties pursuant to a misdemeanor of the second degree. And for the second tier, if a Chinese national violates the law, they get a felony of a third degree penalty. Are there legitimate concerns? Well, there's no question that the Chinese Communist Party would like to get its hands on U.S. strategic assets, so trade secrets, intellectual property, intelligence, and the like. And this is clearly a threat to U.S. national security. However, there's not a lot of data to suggest the idea that the CCP is buying up U.S. property as a kind of stealth invasion. This is the food security threat. There are a few cases that illustrate these concerns, and I won't go into details, but the data, again, is rather sparse. So I think the question that one has to ask is how to make these distinctions between a real threat and maybe an imagined threat. And we have to be very careful in terms of how we make these distinctions. And really the analysis should be to try to identify who are the agents or instrumentalities of the Chinese state or the CCP and who are simply Chinese nationals. Obviously, the two categories overlap, but we have to be clear about making these delineations. So hypothetically, if a Chinese company with links to the state or the Chinese Communist Party is developing a project within 10 miles of the US military installation or critical infrastructure, well, then clearly that's problematic. But if a Chinese national who has lived in the US, in the state of Florida for say 5 years and worked as a dietitian, wants to buy a home for a private residence, that is another thing entirely, right? And it should not be problematic. The legislation and courts must learn to make these distinctions and assess the threat. And if they're not doing it, then it should be CFIUS that's doing it, the Committee on Foreign Investment in the US. Lastly, I wanted to touch on the point of the legal basis in terms of how the state of Florida legislature is able to pass this law. So states have wide discretion under the 10th Amendment and the case law on state rights to enact legislation regarding property regulation within their state. And there's quite a bit of case law on this point. Some of the cases date back to about 100 years old. The terrorist cases in the state of Florida has cited these cases to support their argument. But this power is not unbounded, okay? Many state courts outside of Florida have ruled against the terrorist cases. And moreover, there are arguments under the federal constitution, namely equal protection, due process, and federal preemption, under which the Florida statute is highly problematic. So this point is right now being litigated, as you mentioned, under the case that's called Shen versus Simpson. It's the first case to challenge the Chinese property bans, the 11th Circuit has recently granted a partial injunction in favor of 2 of the plaintiffs on federal preemption grounds, meaning that the state of Florida cannot enforce the statute against them. And my understanding is that the preliminary injunction is subject to appeal, and that the 11th Circuit is next considering whether to grant an injunction for the entire case. So that's where we are with that particular litigation.
Thank you, Matthew, for providing information on the legal context of the law. That's very helpful background. Now I wanted to turn to May to ask about the historical context. As a historian, do you see any parallels between Florida's law and earlier laws in U.S. history regarding Chinese immigration or property ownership, such as the Chinese Exclusion Act or alien land laws? And what can we learn from that history and those parallels?
Absolutely. These new laws are a direct continuation of policies that were enacted in the late 19th century and early 20th century. Let's start with the national security rationale. That was the rationale for Chinese exclusion and all Asiatic exclusion laws starting in the 1880s. And these laws were upheld by the Supreme Court on grounds of national security. Many people don't know that federal regulation of immigration previously had rested on the Commerce Clause. And in upholding Chinese exclusion, the court justified a racist law, which was the exclusion of all Chinese laborers from the country, on grounds that they were agents of a foreign government. So the idea that Chinese nationals today should not be able to buy property because they are agents of the Chinese Communist Party, i.e. the Chinese state, is a very old idea. And this idea that immigration is a matter of national security, more generally, is still the foundation of our immigration jurisprudence. It was a basis for Trump's Muslim ban. And although there are some guardrails against wholesale application of this idea to justify racist legislations, it is still the foundation of immigration law, constitutionally speaking. So this is a very worrisome question because it gives the government almost unbridled power to act against immigrants and foreign-born persons, act against non-citizens, because they do not have constitutional protections in matters of entry or removal. Now, in California and other Western states, there were alien land laws and other laws passed against so-called aliens ineligible for citizenship, which was a euphemism for Chinese, Japanese, and other Asians, from owning agricultural property, also from holding commercial or professional licenses. And this was aimed, it covered all Asians, but it was aimed primarily against the Japanese, as well as South Asians who were successful small family farmers in the West Coast. And this was used the same rationale of national security, openly and brazenly said the Japanese were invading the country by taking over agricultural property. And frankly, this was really about land jealousy, about wanting to, for white landowners, white agricultural interests to take over Japanese farm property. Because it was aimed at nationals, and we should remember that Japanese immigrants were forbidden from naturalized citizenship, so they were caught in a bind. They could not become American citizens even if they wished to. But many of them put their farm property in the names of their children who were American-born citizens. So there were still extensive land holdings by Japanese Americans through the early 20th century. And after Pearl Harbor, there was a mass hysteria about Japanese owning farmland in California. Ironically, some of the plots that they had were strange shaped configurations of property that nobody else wanted, and they happened to be near airports. So this was then, they were then alleged to be spying on American military bases. So we all know what happened next. It was not just that they lost their property, they were interned in concentration camps as a so-called enemy race. right? The presumption was that all Japanese, ethnic Japanese, not just Japanese nationals, but American-born Japanese citizens were an enemy race. So this is where we see this going, I fear. You know, you smear a group with a very old trope that they are an enemy race, they are unassimilable, they can never become Americans, whether by race or by affiliation to their governments. You know, and we don't say the same thing about other ethnic Americans, right, who all have ties to their homelands, sometimes very strong political ties. We could just mention in passing the Jewish community's relationships to Israel. So in any case, I think that this is a very dangerous precedent that Florida is setting. It's even more expansive than agricultural property ownership. And let me just say one more thing. These laws were all struck down. The exclusion laws were repealed during the World War II and post-war era. They were recognized for what they were as racist legislation, anti-immigrant legislation, although the foundational jurisprudence of national security remains. But the alien land laws and other prohibitions on licensing were all struck down by the Supreme Court in the late 1940s on grounds that they were unenforceable and that they were discriminatory. So we actually have case law saying that these laws are bad, that the rationale that immigrants or non-citizens are a threat to national security and therefore should not own property. These have all been struck down by the Supreme Court. Now, I caution to say that the present court has not shown a lot of respect for precedents in matters where it has a political interest. And I'll just be frank about that. So I think we should be quite worried that this is another attack on civil rights and civil liberties. These are racist laws, and we have to question at the first the presumption that all non-citizens are loyal agents to foreign governments. That is a sweeping presumption that we do not hold other immigrants to that. We do not determine what they can do and what they cannot do, what kind of property they can own, what kind of occupations they can pursue. We do not treat other immigrant groups in that manner. So I think this is very dangerous and has a long history that's baked into the legal case law against Asian Americans.
Thank you, May, for the historical context and for the reminder that we've seen similar policies in the United States towards Asian immigrants in the past. And although this session is about the Florida law, we're also seeing some of these themes in other states. And so I wanted to ask Matthew how Florida's law has impacted other states in their lawmaking. Are we seeing other states adopt similar laws? You wrote in a recent article in the Wisconsin Law Review that you called states laboratories of China delinking. I really liked that phrase. But how else have states tried to address this aspect of the US-China relationship? And why do you think that states are pursuing these types of laws?
Thanks, Elizabeth. So yeah, it's important to put SB 264 in context. So it's really part of a larger salvo of state bills and laws directed at China. And as you said, sort of delinking their relationship with China. So based on my research, in 2023 alone, 152 bills were proposed by different state legislatures to delimit Chinese acquisition of property within their respective state. So of those 152, 37 or 24% were passed into law, 56 or 36% died, and remaining 59 or 39% were referred to committees, so to be continued. So I understand that this most recent legislative session has actually seen an increase in the number of China-related bills pertaining to agricultural land and real estate acquisitions. So this set of specifically property-related bills are part of a larger group of state bills and laws directed at China. So this is a very wide sweeping range of issues pertaining to Chinese tech companies and Chinese apps, semiconductors and computer chips, Taiwan, human rights in Xinjiang, education, et cetera. So state legislatures are massively active on this front. I think it's important to note that this is not just a red state phenomenon. So the most active states are Republican states, and based in the Midwest and in the South. So Arizona, Florida, Louisiana, Alabama, Indiana, West Virginia are the most active states there, but also Democratic coastal states, including Connecticut and California, have also been considering these China-related bills, all right, this larger genre of bills, if you will. According to one state bill tracker, New Jersey had considered the most number of China-related bills. There were 9 that they were considering, right? So this is really a sort of bipartisan phenomenon that we're seeing right now. I think it's important to note further that Shen versus Simpson may decide the fate of the China-related property laws in particular. So if Florida wins, then it may embolden states to pass like-minded laws. If the petitioners win, it could effectively stop this type of legislation from being issued in the future. But I think, to go back to your question, what is really driving this is a number of sort of overlapping issues and concerns. And I think it sort of dovetails a number of economic, social, and political issues that are converging on China, and the idea that China represents a sort of existential threat. And furthermore, the perception that the Biden administration has been soft on China. And so state legislatures then sort of filling in the gap and filling in this role and being hyperactive in this space. Now, none of this is to say that there isn't actually a threat that the Chinese Communist Party presents to U.S. national security interests. I think there is one. But I think, again, as I said before, we have to be very careful in terms of how we identify that threat and what we do in terms of penalizing it. So I'll stop there. Thanks.
I think this part of the problem is that the United States, struggles to it wants it both ways. It wants to have trade with China, but it wants to control it in ways that minimize Chinese advantage, right? So the United States does not want to cut all trade ties to China. I mean, that's an extreme position that exists at one end of the political spectrum. I think one of the things the Biden administration has struggled with is how to, agree with the Trump's idea that China was a strategic adversary without going quite as far. And we should point out also that Trump blew a lot of hot air about imposing tariffs on China, and he was only able to do so much. He didn't really get very far because there are actually a lot of business interests in favor of ongoing trade with China. So I think the trade issue is very complicated. It's one of competition, but it's also one of interdependence. And that's an issue that, is not going to get resolved with, hostile legislation that we've seen that is all sweeping and all encompassing. Is China a geopolitical threat? I think that depends on what you consider to be the United States' geopolitical interests, right? There's an issue in the South China Sea. There's the issue of Taiwan. These are serious geopolitical issues. And the United States is involved in that. Whether it should be involved and how far it should be involved is another question for discussion. So I just wanted to clarify my own perspective on that. But I do want to say that a lot of the impetus for these bills at the state level, and I agree with Matthew that this is a bipartisan phenomenon. It's not just red states, it's also blue states. And that reflects as well the Biden administration's own ambivalence or kind of two sides, kind of posture towards these issues. But I think the sad thing to me is that these are really motivated by politics, by China's the easy target. People get all excited when you start talking about China as being the enemy. This is something that we've seen for 150 years. And whether or not there's real issues of competition or strategic interest, it's not the discussion. There's a blanket assertion that China is the enemy. And that is done, I believe, mostly for political gain. It's cheap politics. It's a kind of racial shorthand. And then it gets all Chinese and all Asian Americans become smeared with this brush. The idea that we're not Americans, we can never be Americans, our interests can never align with those of the United States. I'm an American citizen. I was born here. My parents were naturalized citizens. I'm not an agent of the Chinese Communist Party. If I wanted to buy a condo in Florida, I don't. I don't want to live in Florida. But if I wanted to, I should be able to do that. And so I think that what motivates, I think, this rash of legislation is not genuine concern over trade or national security. It's cheap politics, and Asian Americans are harmed materially and psychologically harmed by this.
So if I can just quickly jump in, and I just wanted to say I agree with the vast majority of what Professor Nye has said, and I also agree with the analysis that really what's driving this is this incredible politicization of the topic, and the unfortunate consequence is the racialization of this topic to the detriment of Asian Americans and Asians in the US. So that's first and foremost. However, I would say that, as I said at the outset, that there are clear instances where the Chinese state has operated in a way that's against the interests of the US. So we can't totally dismiss that, right? So while I agree that the threat has been fantastically overblown, I do think there is a kernel of concern, but we have to be very diagnostic about how we understand and how we go after that concern. So as I said, IP, trade secrets, intelligence, those are domestic concerns that China has sought and potentially sought to exploit. If we look at the geopolitical factor, well, if we look at issues of international law, including international human rights law, how China has tried to redefine the nature of human rights and development of human rights, development as human rights, and for example, the UN Human Rights Council, there are clear instances where China is operating in a way that's against the clear interests of the US at a foreign policy level. So again, I think there's actually more that we agree on than we disagree, but I just wanted to clarify my position. Thanks.
Yeah, thank you for that clarification. That's really helpful. I would, what's interesting to me is on the question of trade secrets or IP. The China initiative was started by Trump's Justice Department, continued for a couple of years under the Biden DOJ until it was suspended. And that started out with the legitimate concern of trade secrets or intellectual property, especially defense information, making its way to China. And what happened was it became a witch hunt against ethnic Chinese scientists, Chinese nationals, as well as Chinese American citizens who are research scientists at universities. Some of them were just thrown under the bus by their universities and fired. Others fought it out in court. They didn't find one instance of intellectual espionage, not one. The best they could do was they convicted some people, or some people pled guilty on questions of taxes, right? Not reporting honoraria and this kind of thing on their taxes or on their application forms for federal grants, but they found not one instance of espionage. What's interesting is that I looked at the database compiled by MIT and Princeton and some other schools on all the cases involving intellectual property theft. There are cases, and they're mostly the people found guilty are white Americans who work for large corporations. They're the ones who are trying to sell proprietary information to the Chinese. And I should add that none of this concerns defense industry, technologies, or intellectual property. Those are all classified. Neither the scientists nor the company or private companies have access to this information. So again, I think this is another example of what starts as a legitimate concern becomes totally overblown, turns into a witch hunt against Asian Americans, ethnic Chinese, and Chinese Americans especially. And where the real damage is being done actually is right under our noses, but it's not by the Chinese Americans. So I think that, the politicization and racialization of these issues is, if we're actually interested in, protecting IP, they're going about it in all the wrong way.
So just one last point, if I may, and I think these are really fantastic issues that Professor Nye is raising. And I agree that the China initiative was a fantastic failure, right? So that clearly was the wrong way to go about it. But as somebody that practiced law in China and represented foreign companies operating in China, I can say that the problem of IP theft and trade secrets being disclosed to parties who frankly should not have been recipient of that knowledge, that is certainly a problem that historically foreign companies and other actors have faced and encountered working within the PRC jurisdiction. So I think there is evidence there. There are concerns. So I just wanted to point that out. Thank you.
I thank you both for this discussion and this important back and forth. These are big, important issues. May, I wanted to invite you to tell us a little bit more about the lived experience of people affected by laws like these. If we focus back in on the Florida law and similar laws in other states, what does that mean for Chinese citizens residing in Florida or the United States more generally? Can you talk a little bit more about how people are influenced by these policies or by this heightened rhetoric that comes along with the politicization and broad national security interest rhetoric? Do laws like these fuel anti-Asian bias? What are we seeing as a result of these policies?
Well, thanks for that question. That's really important to know how these affect people in real life. I think there's at different levels. First, I think there's the person who wants to buy property. And I think we're mostly talking about harms to people who want to buy real property, want to buy a house or a condominium. There aren't a lot of Chinese immigrants looking to buy farmland, I don't think. And the percentage of farmland in the United States that's owned by foreign nationals, not just Chinese, is minuscule. It's minuscule. So when you hear things like food security, you just have to laugh because it's not a real issue. But I think there are people who want to buy a house or want to buy an apartment. And unfortunately, the Florida law is so expansive that it goes way beyond what was in the early 20th century alien land laws, which was pretty much pertained only to agricultural property. Although there were some instances of people who could not buy homes in the 1920s. So I think that's on the first level. The second level is, as you mentioned, is that it fuels anti-Asian racism, hatred, and potentially violence. We saw what happened during the pandemic when President Trump accused China of being responsible for the coronavirus and how that turned into a wave of violence against Chinese Americans and Asian Americans in general. So I think that these land laws you can draw a through line from the 19th century through the early 20th century and to the anti-Asian violence and racism during the pandemic to these laws today. So I think it's a very worrisome situation. People who want to buy homes they cannot. And there's an interesting caveat here about the law Matthew mentioned that it's not just non-citizens, it's also non-permanent residents, right? But it takes a while to get a green card, right? And it takes even longer to become a citizen. So there are people who may intend to become permanent residents and citizens, but have not been able to do that. And in the meanwhile, they want to establish their presence in this country. They want to put down roots. And that's the time-honored way in America, putting down roots, is you buy a home. So I think it's very sad and it's very worrisome that people are harmed in this way.
Thank you for providing that context of what it is like for people that are living in states that have laws like these. Finally, I wanted to ask for either of our panelists how state-level laws like these affect U.S.-China relations more generally. How does this impact the U.S.'s ability to conduct foreign affairs with China at the national level? How does that change Chinese immigration to the United States? How is that impacting sort of broader national level policies between the U.S. and China?
Well, I'll just start, and Matthew can add. It does not bode well at all, and U.S.-China relations are not in a good place. This is part of a larger picture of fraying relationships, of competition and bellicose discourse on both sides. I should just be clear: I'm not a fan of Xi Jinping. I'm not the defender of China in this issue. I think that U.S.-China relations need to be recalibrated to be on a more peaceful footing, a way that aims at managing competition and looking for solutions that are contribute to, if I may say, world peace and not to world tensions.
Yeah, on that point, Elizabeth, I agree with Professor Nye that right now the situation is fantastically complicated given the role of sort of subnational actors, right? So state governments, municipal governments included, are all sort of engaged now in China-related questions, and that's very hard from the federal or the central government's perspective, either on the U.S. side or the Chinese side. And so there's a number of different ways to think about how you know, the U.S. federal government should deal with the situation right now, given this complexity, right? And so right now, the courts are in some ways the locus of the debate, with cases like Shen versus Simpson sort of winding their way through the federal judiciary. And there's other cases as well. There's recent cases following this on land issues, but also on the issues on the prohibitions on Chinese apps that are also there are other cases on those points that are being litigated right now. So I think the courts are trying to figure this out and balancing state interests versus the federal government. But also, to some degree, Congress is now kind of potentially leaning in a bit. So Representatives Judy Chu, Democrat from California, and Al Green, Democrat from Texas, have sought to introduce federal legislation that would preempt laws like the Florida statute that we've been talking about. So, right, so stepping in with an explicit piece of legislation that would then ensure that states could not then try to override what the federal government has already legislated on. The executive, could the executive get involved in this? Well, hypothetically, the president could issue an executive order, but I think right now where we are, and particularly as we're entering the election cycle and as we start marching towards November, that it's unlikely that that something like this would happen. And I think it does sort of raise the question in terms of what does the situation look like in terms of the U.S.-China relationship if Biden wins or if Trump wins? And I think there's different scenarios that could be possible under those different situations. But the last point I want to say is, you know, I think the federal government sort of needs to do more in terms of centralizing its policy vis-a-vis China right now, but that centralization should not necessarily exclude state governments, because state governments are extremely important actors in what's happening right now. So marginalizing them or pushing them out of the conversation, I think, would be detrimental. But I think there needs to be more work done in terms of trying to harmonize these very diverse interests.